We are permitted to mention item number 52. There is certain urgency in this matter. If it can be taken up today or upgraded in the next week.
Give your slip, sir.
Very permitted to mention, my lord.
Much obliged.
Give your slip with reasons for upgradation.
No, I'll write it.
I think you're appearing for the first time here.
In your court, yes, Lordship.
Please read the list. There's a method. There's a system.
I'm doing that.
Give your grounds of urgency. We'll see that.
Very permitted to mention, my lord, upgradation of application matter. I've given the urgency, my lord. Unauthorized construction, going on municipality, it's unauthorized. Don't take any step. It is right.
Give your slip, sir.
Yes.
Well, regarding item number 69, my lord, I have the same prayer, my lord, so I'll hand over the slip there.
Give the slip.
My lord, I'll show that.
Heavy lordship can
At least give the ground of urgency so that I can see.
I shall, my lord. I shall.
Lordship, I want to mention one matter for upgradation.
Give your slip.
May I mention a matter for extension of it?
My lord, like the absolutely new motion in the monthly, maybe in the monthly list of September.
What new motion? Upgradation or what is it?
Inclusion in the list for motion. Inclusion in the list for motion.
Inclusion in the list.
My lord, under compelling circumstances, I am mentioning a matter for upgradation. Item number 2689 of common monthly list of July of affiliate side. My lord, I've earlier mentioned on Monday, but the matter did not appear. My lord, this is a matter of urgent because respondent number 899 has illegally mutated their property in their name, and they have entered into a development agreement with respondent number 11. And I'm praying for the cancellation of the mutation. That's why, my lord.
Give your slip, sir. We'll see that.
Lordship, seek leave to mention a matter, my lord. It's running in the daily list under the heading hearing, my lord. My lord, the difficulty is the company is operating without the trade license, my lord. And as far as the issue concerned in the writ is concerned, my lord, it has been completely settled by way of a government order.
Give your slip and see.
Grateful.
Yes.
My lord, in this matter, my lord, initially after hearing the parties, my lord's pleasure was to hear the matter upon use of affidavits, my lord. So, my lord.
Item number 1.
My lord. My lord, only when the extension of the interim order, the heading, my lord, the matter has come, my lord, the interim order need be extended. Last order was passed.
Has the affidavit?
Yes, my lord. Yes, my lord. Affidavits are already exchanged, my lord.
Then let's hear the matter.
My lord, had heard Mr. Kaur in this matter, my lord.
Yes.
He has some medical reasons, my lord. So, my lord, he is hospitalized, my lord. That's the reason. I believe it was indicated, my lord, to your lordship.
No, it was not indicated. What happened?
My lord,
Not well.
You need to go some surgery, my lord. That's why, my lord. So,
Affidavits have been filed.
Yes, my lord. The reply I have just now given to my lord's officer. KMC has given the objection.
Gopal. So this you're filing today?
Yes, my lord. Here and now, my lord.
Take down.
And for the state.
Yeah. Ria, likho. Affidavit in reply of the petitioner to the affidavit in opposition of respondent number 2 and affidavit in reply to the affidavit in opposition of respondent number 2 and 3 is taken on record. Full stop. Interim order expiring when?
But yesterday, my lord, it has already expired, my lord, but it was mentioned.
Interim order granted earlier is extended further for a period of 4 weeks or until further order, whichever is earlier. 6 weeks. List after 4 weeks. Give it. Interim order 6 weeks and list after 4 weeks. 4-week date though. Give the date.
Yes, ma'am. Kindly give a date. Thursday.
28th of
August.
August. Take it.
My lord, August 20. Deeply.
My lord, in item number
I beg to appear on behalf of the petitioner.
Item number 7.
Yes.
This is the application for restoration application, Lordship, before your Lordship.
Yes.
The order was,
Some other people were supposed to
Yes, and
join.
it
What
may
are
be
that?
sorry, the manager, your lordship, I have filed an affidavit in opposition to the restoration
That is point
application,
number 7.
lordship.
What happened? There were other petitioners also.
this one is the change in brief, Lordship, that others have not filed with any application before your Lordship. I being the petitioner number 4 before your Lordship, I am filed this restoration application before your Lordship for the
That's-
restoration of the main suit or main read petition to be restored, Lordship. Then the Lordship may please to expand the names for who has not appeared before your Lordship. The name may be appeared as the pro forma respondent, but I being the petitioner number 4, it is my right to file this restoration application, Lordship, and there maybe Lordship may please to restore my read petition. Then Lordship may please to decide that the other petitioner may be as being the pro forma respondent.
So last time somebody else was appearing and he had
Mr.
stated
Siddhartha
that they
Banerjee
are
was appearing, he prayed for time for last thrice, your lordship, because
thrice on the ground that some other persons are also joining you and
Okay.
filing the.
But now at that situation is this, Lordship, none of the parties may appear before your Lordship to file any application. I am for the petitioner number 4. I am before your Lordship and I am praying before your Lordship. Lordship may please to restore my
We'll allow
petition.
qua him only.
The thing is, this jointly petition was weak. Now, my lord, it was dismissed for
Default.
This is for default.
and my lord, some of the petitions, my lord, want my lord, for restoration of the petition.
Only he wants it.
Yes,
My lord, they can if they, my lord,
Only
obtain it,
qua
they
him
can-
will restore the petition.
yes, Lordship.
your lordship can make it a short passover so that Mr. Banerjee is there, he's just, if your lordship would permit, only a short passover, your lordship.
Passover won't be possible. Why Passover?
This is the
So we'll
restoration,
have it next week. Then.
restoration application, Lordship. Lordship may please to.
No, Mr. Banerjee is opposing. I know it.
Your lordship, Mrs. Shah is
Yes.
also there. Joseph, can you take-
My lord, from the last few times they have taken time saying that a new application is forthcoming.
Not
I don't
coming
know.
anymore.
Then my lord keeps it on next week. My lord will argue it out because we were under the impression that that application would be coming out.
Keep it next week. At the request of the parties, that this matter be listed on next Thursday. क्या है?
Grateful, Lordship.
Grateful, my lord.
next week. Now, this is the
I seek to appear on behalf of the petitioner. My lord, Lordship, kindly recall, my lord, the retired professor of Rajabajar Science College, my lord, himself mentioned this matter on the last occasion since without notice. My learned senior friend took time. my lord.
তাকে দিয়ে mention করেছিল।
No, certainly not. It is his discretion.
Yes.
As you kindly see, my lord,
এই opposition bill.
page, and this is our, my lord, the affidavit in reply. Kindly see, my lord, page 17, 18, and then, my lord, 19. My lord, a repairing plan is enclosed herewith. In the garb of repair, they are doing, my lord, construction. And I am, my lord, next door neighbor, my usementary right, my ancient right to light and air and everything has gone, my lord.
These are these 28A, B, C.
Yes, my lord, Badur Bagan Road. My lord, at point of time, the Vidyasagar was there, my lord, in this particular road, living there. Now, my lord, kindly see the back portion of this page 19. First, my lord, the front portion, then, my lord, back portion. The plan, my lord, lordship, got it?
Yeah.
Kindly proposed additional puja room, lordship, got it?
Yes.
Proposed additional puja room, then prayer room. So one is puja room, the other is prayer room. Toilet, and I don't know whether for the DT this toilet is needed. And proposed stair from the second floor level to the roof and stair head room at an existing two-storied residential building at premises number 28C Badur Bagan Lane, ward number 38. My lord, this existing two-storied building, my lord, there is a fallacy, my lord. What happened? The plan they are not able to produce. My lord, this honorable court appointed, my lord, a commissioner, court commissioner, went there, repeatedly requested to show, my lord, the plan. Neither corporation, the custodian of all record, my lord, nor, my lord, the private party show their plan, my lord. If there is existing building, then only, my lord, addition to be given in terms of the circular, though that is not permissible. That is why we are asking for cancellation of this plan. Lordship, kindly see in the middle portion, second box, third box. This is to certify that the building plan has been drawn as provision under section 410 of KMC Act and circular number 9. My lord, under section 410, no plan is to be granted. The provision is 393 of the Kolkata Municipal Corporation, 390 of the Kolkata Municipal Corporation. And then, my lord, circular. Lordship, my lord, this is administrative circular. If it is not within the four corners of the statute, my lord, the administrative authority is not permitted to do this thing at their own will and volition. That condition of the site, including the existing structure as per legal document and width of the abutting road, so and so, my lord, that being the situation. Next, turn to, my lord, next page. At the top, my lord, it is written parties copy. Next page, back portion of this, my lord, so-called repair plan. Kindly see, my lord, first paragraph, serial number, third line, valid up to, my lord, 47 to
Mr. Chakravarti, your client
Yes.
mentions the matter himself, mentioning it as himself,
Yes, my lord.
right? Not through you. So he portrays to be petitioner in person.
Yes, my lord. If that be so, my lord,
Which
because,
is
my
not
lord,
right.
not getting accommodation, that is why in out of
That is not right.
true, my lord.
That's
True,
not
my lord.
correct.
At the same time, in utter
Wrong.
desperation, he has moved. My lord, he will come, my lord.
Wrong interpretation, a wrong idea to the court is not
True, my lord. True, my lord. My lord, I apologize, but this is, I have no, my lord, instigation or all other things. This is at his own will and volition, my lord. He came before this honorable court and moved. আসুন আপনি। আপনি আসুন বলুন। এখানটা দেখেন। যেই আপনি বলেছেন, জজ সাহেব বলতে চাইছেন যে এটা আপনার দায়িত্ব হলো জজ সাহেবকে আপনার বোঝানো।
No, he should have asked you.
Yes, my lord.
If you are representing, you are the advocate on record,
Yes,
he should have asked you to mention it.
My lord,
It's very unfair on his part to come and give this impression to the court that he is a petitioner in person, citing his age. This court has allowed it. Anyway, we'll decide it. But this is very unfortunate and unfair on his part.
Only one argument in my favor. Lordship knows nowadays YouTube and other things are going on. My lord,
But
why
you are the lawyer on record, Mr.
no,
Chakravarti.
my lord, widely circulated, the parties are moving, drawing the attention of the honorable court on could entertain them because of possibly because that reason, unless, my lord, so far other clients are concerned, Lordship knows, my lord, never it happens. He has done his out of his own, my lord, sagacity. I have no instigation, nothing of this sort. I may be, my lord, I am apologizing. My lord, I have no role to play. Kindly, my lord, my lord, my unqualified apology may kindly be accepted. I have not done it, never, my lord. Either he will hear or myself be.
No, I know you.
Both
That's why
cannot, my lord. Both cannot.
I know you, Mr. Chakravarti.
Deeply
That's why I was very surprised.
Deeply obliged, my lord. Deeply obliged. My lord, my learned, my lord, the petitioner here in May, my lord, place his case before this honorable court. But if this honorable court kindly permit.
I don't want to
Oh, yes, my lord. Yes, my lord.
prejudice. Yes, tell me. Tell me.
Yeah.
Yes.
My lord, once again I tender unqualified apology and, my lord, then placing it. My lord, not to be repeated. Henceforth, if it happens, I will leave the brief, my lord. I undertake this thing. I will leave the brief.
Yes.
My lord, kindly see the party's copy.
Yes.
Lordship will find third line, backside of that particular plan,
Yes.
valid 2 years from 4/7/2022, approved by the executive engineer. My lord, the provision of the law is the municipal commissioner at the helm of the affairs to a grant sanction building plan. Then, Lordship, kindly see, this is very important. Within boxed, reconstruction of roof.
Yes.
Reconstruction of roof. Not to make any construction, my lord, fresh construction. Only roof. If it is damaged, then I will show, my lord, the rules also.
Yes.
Of CMC building rule approved on 22nd June 2022. Then, my lord, Lordship, kindly come to, my lord. At the bottom, plan approved under Rule 32 and 141 of the building rules, 2009, read with section 410 of the CMC Act, per resolution of the MIC meeting by the agenda number so-and-so, dated so-and-so, on condition the existing building in the approved plan should not be considered as regularized on the basis of undertaking submitted by the applicant structural stability certificate of the existing structure, my lord, so and so to be given.
Yes.
আপনারা mail করে দিয়েছে। Mailed it.
Sorry, my lord. for
I have mailed
interruption,
it, my lord,
lord.
yesterday.
That the reply has not, he said he has mailed to junior advocate possibly. My lord, that copy, my lord, I just now received, I could not.
And
go through
further-
My
it.
lord, we have
And
tendered it, they refused.
And furthermore, it is about cancellation of a building plan. So corporation also requires to file an opposition, not the report only.
My lord, there was a direction to produce record.
No,
Last
and
occasion,
then cancellation of building plan cannot be done without any opposition.
My lord, they
That is a law point.
took time, my lord, on the last occasion.
Maybe.
Kindly see, my lord, the last two order.
Maybe.
There was a
Yes.
Building plan cancellation.
At the same time, when I'm drawing lordship attention, the order dated 20th November 2024. That was not challenged against.
Already file your affidavit and
Yes, madam, I have to.
learned counsel for the respondent corporation seeks and is granted. How much time, Mr. Banerjee?
Madam,
How much time?
4 weeks.
4 weeks time to file his affidavit in opposition. Reply to the same if any. 2 weeks. There are 1 week or 2 weeks?
Yes, no, one week.
One
Only
week.
my lord, 20th November
no.
order may kindly be
No.
looked into for a while. What is their reply? They should, my lord, indicate. Second page, my lord. The court is of the prima facie view that respondent number 8 should modify the structure by setting it back at least 4 feet from the common boundary wall.
It was a prima facie view.
Deeply up.
Thereafter, many things have happened. Thereafter, many things have happened.
Many
Mr.
things have.
Chakraborty,
And I have to file an opposition regarding everything.
Reply within 2 weeks.
Within 1 week.
Within 1 week. Reply within 1 week thereafter. Reply if any within 1 week thereafter.
Not a date may kindly be.
List after 8 weeks.
Not a particular date may kindly be.
Chakraborty plays the correct thing before the court. When he refers to a court, my subsequent events also to be told.
Okay. 25th September.
Deeply up. 5th September.
20?
Yes,
25th September.
25th
The
September.
25th is the last day of the court. In any manner, my lord. I
Let
think.
it
court
be
will
2
not-
weeks, my lord. Let it be 2
No,
weeks.
cannot. Practically, today was also very impossible to come.
I was not expecting you.
I just rushed and come. ছাড়ান না, এমনি এমনি
My lord,
I am for the petitioner, my lord.
Hey, मेरा वो
আমাকে দিয়েছে আমাকে
আরে আজমি না কি হয়েছে? আজের ভাই
just now I have received
Just
Well,
now I have
I've
received
the
the
report,
copy.
your lordship, my lord,
Just
that
now I have
actions, my lord, regarding the updated information regarding the actions, my lord, for demolition of number of certain numbers of buildings, my lord.
just submitting your report.
My lord,
just now minute I have
Time may be granted, my lord, for filing my exceptions, my lord. I need to file exceptions.
it is
petitioner. What?
The report filed by the Calcutta Municipal Corporation is taken on record. Learned counsel for the petitioner seeks and is granted. So you're the petitioner.
1 week. Yes, my lord. I am for the-
2 weeks time to file his exception to the said report. List after 4 weeks.
ওরা বলতে পারবে আমি জানি না আমার আমার 28 বলে ব্যাপার আমার 28 বলে আমার
অ্যাকশন নিচ্ছে আরে ভাঙার তো কিছু কিছু অ্যাকশন নিচ্ছে
আমার তো
May it please your lordship, my lord, I am appearing for the private respondent number 7 in this matter. Private respondent 7.
My lord, I am for the petition and lordship. After listing the matter before your lordship,
Thank you.
corporation my lord asked us to submit all the relevant documents before them to obtain the mutation on behalf of the petitioner lordship. Therefore, lordship, I am praying before your lordship to kindly allow us some time to complete the issues, lordship, with the
Well,
corporation.
so is the case with the respondent number 7, my lord. Her name was mutated in the assessment
Praying
record of the
before your
Calcutta Municipal Corporation, and my lord, he was paying the tax, my lord, and as an owner, my lord. Surreptitiously, without any notice and without giving an opportunity of hearing, my lord, then, my lord, my name has been shown as, my lord, occupier, my lord. Similar type of, my lord, the grievances, my lord. In respect of 1 cottage, 5 shutters, and 53 square foot land. Total occupation in my occupation.
In this matter, lordship, I am praying before your lordship to fix the matter after my lord 3 weeks to my lord complete the issues.
Are you aware of the notice which the corporation has served upon him?
No, my lord. At least no notice has yet been served upon me, my lord.
You are
My
the
status
advocate
has
on
been
record.
changed to
Who's the advocate on record?
My lord, the Vishwarup Acharya, and my lord, I am led by Mr. Banerjee.
Yes, Mr. Banerjee.
Yes, my lord. My lord, we have received a communication. I just need to inquire what is the form, whether it is written or not. Where my lord, the authority has asked us to speak to them, provide the documents so that they can incorporate our name in the certificate, in fact, mutate our names. So I would beseech your lordship kindly keeps this matter in the last week of August so that an amicable settlement can be achieved. And if not, then we come back to your lordship. Affidavits
Alright.
have been exchanged in this matter.
Take down. Learned counsel for the
so
petition.
for my party is concerned, will let it notice be issued to me, my lord, so that I can, my lord.
Corporation will do that.
Yes, my lord.
I'm not
copy.
recording anything.
No, my lord.
Learned
Because
counsel
my
for
name
the-
was mutated and, my lord, I was paying the taxes, my lord. Actually, I am paying taxes in respect of the portions I have made.
Sir, Mr. Mathi, if they are going to cancel your mutation, they will inform you.
No.
They will not cancel
But I
your
have been shown as
mutation.
occupier only, my lord. Not only.
Whatever it is,
We are not asking for cancellation of their mutation. In fact, no one is.
learned counsel for the petitioner seeks an adjournment on the ground that there are chances of they seeks an adjournment. Let this matter be adjourned for 4 weeks. Not record anything. I'll not record anything.
But let it come back in the same position in the list once it is.
That I can't be sure about. 4 weeks. 4 weeks you want, right?
4 weeks, my lord.
Yes. What was the date?
I'm deeply obliged, my lord.
Item number 6. Yes.
On the last occasion also petitioner is not appearing. Your lordship, 2 matters have come up before your lordship.
So one matter they have already withdrawn.
Already delisted, my lord. Already
This one you have to take action.
my lord, today we have taken action,
Yes.
but your lordship knows only partly demolition. That is not fully. That is over the telephone, my lord. Last occasion also they are giving regarding the demolition case, regarding our
You
execution of
file your report.
lordship.
Mr. Das, file a report indicating the action which you have taken. An action taken report shall be filed. Last time also you have taken time.
My lord, in this matter I have not taken time, my lord. We have already filed 1 or 2 action taken report. If this is on in your lordship, I don't know, my lord. I have already filed 1, but thereafter in different proceedings, different persons. I will file. Give me some time. I am first time. This is my lord. Your lordship is hearing this matter.
Learned counsel for the respondent corporation seeks and is granted. How much time? None for the
My lord,
petitioner.
4 weeks time may be given, my
4 weeks to file his report by way of an affidavit.
my
List after 4 weeks. After 4 weeks. You have started using mail now?
yes, my lord. Again, grateful lordship for your.
I'm appealing for the state response.
That's right. Appear for the appellant. Mr. Mitro is not available today. He has requested me to seek for a not today.
Yes, exception. Who was supposed to file an exception? You
Yes, possibly I am not equipped today. Nobody is there.
Your exception is awaited, sir.
Possibly it has been filed, Your Lordship. I don't have proper instructions today because I'm handicapped.
All right,
Yes.
proxy counsel so and so appears and states that the main arguing counsel, Mr. S.N. Petition. Proxy counsel, give your name.
Yes, Your Lordship.
So and so appears and states that the main arguing counsel, Mr. Surjit Nath Mitra, is in some personal difficulty. He prays for an adjournment. Full stop. Let this matter be adjourned to. How much time you want?
Lordship, only for the today. Only today.
Next week, my lord, maybe in the leadership posting, my lord. What do you mean?
28th.
Grateful.
Grateful.
If my lord, I am happy with the corporation.
My lord, I am for the petitioner, my lord.
Report, my lord, I am submitting.
Just submitting the report.
Well answered.
My lord, we have received a copy just yesterday of the report.
You need time?
My lord, just a week to take out an exception, if your lordship may kindly permits.
Yes. The report filed by the respondent to number 1, 2, and 3 is taken on record. Full stop. Learned counsel for the petitioner seeks and is granted 2 weeks time to file his exception to the said report. Let this matter be listed on 2nd September.
Grateful, my lord.
You know, speak on 2nd of September.
2nd September. Any difficulty? None for the petitioner. In the interest of justice, adverse orders are deferred.
I appear for the response.
None for the petitioner. In the interest of justice, adverse orders are deferred. Let this matter be listed on 2nd September. Adverse orders are deferred. In the interest of justice, adverse orders are deferred. Let this matter be listed 2nd of September.
Item number 11. 11. I'm appealing for the state response.
Lordship, I appear for the petitioner, Your Lordship. Item number 11. Yes, Your Lordship. In this matter, Your Lordship, we had placed before Your Lordship that several RTIs were made by the petitioner against an illegal construction of the private respondents, and the corporation had admitted in the RTIs, Your Lordship, that there was an illegal construction deviation from the sanction plan, and this has been going on from Your Lordship from as back as 2014. Till date, Your Lordship, no steps had been taken. On the last occasion, Lordship had directed to file a report. We have not received a copy of any report. Neither we have received any copy of the opposition which the private respondents were supposed to file, your lordship.
Who's appearing for the KMC? Who's appearing for KMC?
Mr. Srijan Naik, my lord. Mr. Srijan Naik is for the KNC, my lord.
He is not here today.
He is from courtroom number 15, my lord. Will it be taken up tomorrow, my lord?
Next week, not this week.
Not this week.
Next week.
Okay.
Fourth September. Sorry, Mr. Ghosh, in the last matter, it will be 4th September, not 2nd September. 4th September.
Number 12.
So in this matter, I was trying to take instruction the last notification that was taken now. But unfortunately, my learned junior friend wished to, my lord, to intimate to the authorities, my lord, to meet him and to have the instructions regarding that. You know, he posted, my lord, after 2 weeks, my lord, so that I can, my lord, in the meantime, take instruction.
None for the petition. Same order karna. In the interest of justice, adverse orders are deferred. Rest after 2 weeks.
Yes.
2 weeks. 2 weeks will be 14.
Item number 30.
Madam,
I am for the applicant.
Your lordship.
The issue regarding mutation raised by the petitioner, I have applied for intervention because, my lord, I'm in possession of the property and I have title. According to me, according to them, they have title.
Lordship, however,
That has to be decided by the corporation.
Lordship, I'm only asking for 2 weeks. I'm only praying for 2 weeks. Mr. Joydeep Kaur is leading us in this matter. He's undergone surgery this morning.
I know. It's not well, yes. Proxy counsel so-and-so appears and states that
I'm praying for 2 weeks.
senior
Your lordship.
advocate, Mr. Joydeep Kaur.
I think Mr. Banerjee is there, isn't he?
It's
What is that?
Has undergone a minor
my
undergone a
instruction
surgery.
from my
She prays for a short
my instruction.
adjournment. Let this matter is unwell. Is unwell.
He's undergone surgery this morning, Your lordship.
Prays for a short adjournment. Let this matter be adjourned. How you want it for 2 weeks?
Yes, Your lordship.
2 weeks. List after 2 weeks. 14th.
Yes, no, lordship is keeping it on the 14th.
14th.
Lordship. I'm grateful, Your lordship. नाम लिखिए.
Yeah, 14.
I am to take my.
I am for the corporation. नाम दीजिए.
None for the petitioner. You are appearing. Who's for the petitioner? Nobody.
No. তুমি তো petition no. কেন ওখানে দাঁড়াচ্ছ?
Yeah, Ria, just put that. None for the petitioner. In the interest of justice, same order. Adverse orders are deferred. When do you want, Mr. Banerjee?
Any day, but 2 weeks, man.
2 weeks. 14th.
Oh, man, 3 weeks. 14, I
3
will not be there.
3 weeks will take us to, then make it 4 weeks.
4 weeks, man.
28th.
28.
My lord, I am appearing on behalf of the petitioners.
I appear on behalf of the respondent number 8 and 9.
My lord, the petitioners, they are the senior citizens and the residents of a particular area where the private respondents reside. And my lord, kindly straightway comes to page 39 and 38. Your lordship will find the private respondents number 6 to 9, how they have constructed their house at the corner plot. My lord, kindly comes to page 38. This is the house without sanction plan, a corner plot, my lord, no ambulance nor fire brigade car that can enter into the house. And my lord, kindly sees how they have erected this staircase illegally by way of using cement blocks. And then page 39. These are the houses, my lord. Page 39, my lord, I have drawn up, I have marked the portion how they have illegally erected this portion, for which, my lord, no big car they can enter. My lord, next part of my submission will be complaint has been lodged, mass complaint has been lodged before the executive engineer, survey department, Kolkata Municipal Corporation, page 32, page 42 and 43. A complaint was forwarded to the deputy mayor, pursuant to which a joint inspection was conducted, page 48. Thereafter, nothing was done. We even do not know what was the result of that joint inspection. কোথায়? না না সেটা verbal বলেছিল না। Page 49, my lord, kindly sees. I am reading, sir, on receiving complaint from resident of nearby area of 45, 45 by 1 and 48 Anantnath Dev Lane, Kolkata 37 in ward number 003, Borough 1, which was duly forwarded by Honorable MLA. A joint inspection will be held at above mentioned area on 22nd of March 2024 at 3 p.m. You are requested to be present with relevant documents at the aforesaid premises on the date and time above mentioned. Here, thereafter, my lord, kindly sees. Page 50.
Yes.
My lord, thereafter nothing happened. Our instruction is, my joint inspection was done regarding the illegal construction of these two corner plots. Thereafter, everything is silent. We do not know what is the result of that joint inspection, what they found.
You stay just next door.
My lord.
Where do you stay?
My lord, same area, my lord, same area. Inside, these are the corner plots. At the, my lord, entrance of the area, we reside in the inner side of the area. Page 33, my lord, will clear the situation. Page 33.
This is the illegal construction.
আর আমরা থাকি ভেতরে তো?
This 32 feet connected.
My lord, this is at the bottom portion. These I have marked in black ink, my lord. These two are the illegal constructions. We reside in the my lord, inner area, the upper side. 32 feet wide road. Inside is 32 feet wide road. But the kindly sees the condition of the common passage.
This is 20 feet. This is the
Yes, Mr. Ghosh.
Yeah, this is that it has been inspected. That's it that the building has not been has been laid the recently or the recent past. It says, my lord, the old two-story building, and possibly, my lord, it has been constructed as it appears from the local inquiry that more than 50 years, my lord. That is, my lord, what?
Look at the building.
Looking at the building, my lord, that is they have said.
Mr. Ghosh, please have page 41.
The photograph, my lord, this is
Please have page 41.
the photograph, my lord, is Xerox. My lord, I cannot.
You have my file. Give
48 by 1.
my file to him.
48 by 1.
Hey, Manoj. Gopal, file. See, please see page 41. 41.
41 টা দেখাচ্ছে না? এইটা 41 টা দেখো।
Years, he said. But this is 48C.
Page 41.
Page 41. Page 41, see the stairs, the way it has been constructed. It is complete encroachment on public land.
I appear on behalf of 48C, Mallet.
I'll hear you.
48C, my lord, yes.
Look at the way the stairs have been constructed.
Yes, my lord, I see, my lord, the stair, my lord,
And this is recent. This is not old construction.
But as this building or the, my lord, the stair is concerned. Stair, my lord, I will take instruction about that, my lord. They say, my lord, whatever the report, they have not given, my lord, 48C. Because 48C, my lord, because I.
So you file a report.
48 by 1, they have given the 48A by 1. But the report has not come on 48C. Because this provision is 48C.
Yes, you file a report because they are alleging on. File a comprehensive. Yes.
The only thing that I appear on behalf of
Yes.
respondent number 8 and 9, this is our house, Mallet.
Yes.
But we say it's an old house, long back, Mallet, the 48C. Is
Whatever it is, sir. Old house, new house.
But which is within the Mallet, this concrete pillar markers, Mallet. These are not new constructions, Mallet. And they what they say, that the cars cannot enter, Mallet. I have photographs to that effect. The cars are entering every day.
It doesn't matter whether cars can enter or not. Any encroachment on public land.
It's not an encroachment, Mallet. But that representation which they say, Mallet, we were not called for the inspection also, Mallet. Only 48 by 1 was called for the inspection. You see, Lordship sees 49, page 49 once, Mallet.
Yes.
But the inspection nearby area of 45, 45 by 1 and 48 on Onadbun Deb Lane, Mallet. 48C was not called for inspection, Mallet.
Now they'll call for it.
But their prayers is for representation be considered, Mallet.
What do you want, your representation or you want a report?
But they want the representation for being considered, Mallet. If the Lordship sees the prayer, Mallet.
My lord, we have prayed for removal of the illegal construction. Removal of illegal construction. Page 25.
But we were not given any hearing, Mallet.
Page 25B, removal of the illegal construction.
The corporation has not given us any hearing, Mallet. 48C was never called for joint inspection, Mallet.
Whatever they have to do, they'll do it. Take down. The petitioner in the present writ petition is challenging the
removal
inaction of the respondents, whereby they failed to take any action against the unauthorized construction made at the instance of the private respondents at premises number 48A/1 and 48C, Anantnath Deb Lane, Belgachia, Ward number 3, Borough number 1, Calcutta. Thereby encroaching upon the public land and carrying out illegal and unauthorized construction in violation of the building plan, sanctioned building plan. Whatever will be the width of the road, you'll ensure in the layout plan that it should be that much. Learned counsel for the petitioner states that the roads have been encroached upon by the private respondents, and it is not possible for any vehicle to enter the said area due to such encroachment. Full stop. Learned counsel for the petitioner states that he has made several representations before the respondent corporation, but the same have not been acted upon. No, ऐसे कर दो उसको. Learned counsel for the petitioner states that he has made several representation before the respondent corporation and finally a joint inspection joint inspection was conducted by the executive engineer building on 22/3/2024. Full stop. 21/3/2024. Though there has further learned counsel for the petition submits that there has been no follow-up action after the inspection, and petitioner is unaware of the report inspection report. Full stop. Learned counsel for the private respondents submit that the building is an old building, and
I am appearing on 8 and 9. I am appearing on behalf of the respondent number 677.
Very good.
My lord, this is very old building.
Very good. That's what I am recording.
Yes, my lord. And the sanction has already been given by the.
That's what I'm recording.
Yes, my lord.
Learned counsel for the private respondents. The respond numbers
8 and 9.
8 and 9 as well as the respond number 6 and 7 state that the said building is an old building constructed in accordance with a valid sanction plan, and that they have not carried out any encroachment or unauthorized construction in the said building. Full stop. Learned counsel for the respondent corporation seeks and is granted. Mr. Ghosh, how much time? 4 weeks time to file a report by way of an affidavit after conducting a fresh inspection to ascertain the nature of illegal and unauthorized construction as well as encroachment on the public land, leading to difficulty in vehicular movement, i.e. for movement of ambulance or any special services. Full stop. Let this matter be listed after 6 months.
I bow down before your lordship. There is a specific section and rule regarding the corner plots. That has to be seen, my lord. Regarding corner plots, there is specific rule. At least, my lord, they should inquire about that because these are the corner plots.
My lord, it's already, my lord, kindly see this.
Just a minute, sir. You can make all this submission before the corporation. I don't have to see. I'm not passing an order of demolition. ऊपर जहाँ petition submissions है ना, petitioner further submits that these the said buildings are corner plots and that the same are covered by
section 405 of the Act.
He can, but I something. He can LOC has directed task to make an inspection in presence of all the parties. Whatever their contents, they may raise theirs. Now, my lord is saying about the corner plot. Corner plot, my lord, is section. There is a particular provision regarding the straight corner that is to be left out. There is a provision.
Yes.
Just, my lord, what has happened?
I'm just recording his submission, nothing more.
Nothing more. Grateful, my lord.
क्या लिखा है? Learned counsel for the
Petitioner further submits that the same building are corner plots and
covered by rule.
My lord, section 405 of the Act.
Section 405 of the Act.
Rule only Act section.
Wherein section 405 of the Act.
Grateful, my
ऊपर डाल देना. List after 6 weeks. 6 weeks.
After 6 weeks. Grateful, my grateful.
Time for CSU. No. Well, 16 has perhaps become infructuous in view of the subsequent development, let it be treated as infructuous. That was the instruction which was directed to be taken.
16 is for the municipal. My lord, I appear on behalf of the petitioner. In 16, my lord, the corporation, my lord, had disclosed certain documents. Now, those documents, luckily for us, my lord, clearly show that the action that has been done is unlawful. Now, that is why filed a new writ petition challenging, my lord, the entire gamut of actions in the light of the discovery made now. That writ petition is appearing as item number 72 in my lord's list today. We could file it yesterday. We've sent copies by email, but frankly, my lord, that is no service. We have.
So you are withdrawing this writ petition.
Please, my lord, kindly keep it intact because.
Why should I keep it intact, Mr. Man?
We made all the prayers there. So
I'm not going to keep this intact.
In the view of filing of the fresh writ petition, my lord, we are.
Learned counsel for the petitioner, Mr. Banerjee states that they have filed a writ petition number
574 of 2025, which is item number 72 of today's list.
574 of 2025. And in view of the same, he wishes to withdraw the present writ petition. The same is dismissed as withdrawn. Along with application. Is dismissed as withdraw along with all the other applications.
Lord, may I hand over copies, Lord, of that writ petition, Lord, to Mr.
It is better that they
Let it
submit
come
there.
to the corporation. No, grateful.
But this my application, the writ petitioner's application in the pending.
Lord, item number 17.
In matter, your lordship has taken up on my lord on 17 July. On 17 July, my lord, there was some disputes between the tenants and the petitioner.
We will see all this. We will see all this.
Matter to the conciliation proceeding.
Sir,
It is started.
I am not saying anything. We will wait for the conciliation proceedings. Then we will take this.
Get over.
I'm grateful.
Rejected.
No, my lord. Kindly see the prayers, my paragraph 6.
Well, till the time the mediation is going on.
Held a sitting.
Sir, when I'm saying something, listen to me.
Yes.
Wait for the outcome. All right? Heavens are not going to fall.
Separate issue. But I am praying before your
You are praying for is that they should consider your application, which you have filed.
No, not consideration. I am saying that certain steps are required to be taken by the KMC authority.
Let them come back. Let them come back.
My lord, the entire gamut of the dispute is being referred to the mediation.
Let them come back. With the report, we'll see.
Along
with the men.
Yes.
Deeply obliged.
Let this application be listed along with the main writ petition. What is the date? We have given a date, returnable date in the writ petition.
My lord has given 12 weeks returnable, 12 weeks.
17 July.
Whatever it is, we have given a date.
Yes.
My lord, 6th of November 2025. Only one thing, your lordship, on the last occasion, your lordship referred the matter to mediation.
Writ petition on 6th of November.
My lord,
November.
My lord, somehow if the mediation, my lord, does not, my lord,
then we'll decide.
My lord, let the oppositions be filed, my lord, affidavits be filed on.
First, you.
Very well.
Let us first come back from mediation.
Thereafter. Approach. I know nothing will happen in mediation.
Your lordship?
If this is your approach today.
No. My lord, my lord.
This is
your lordship. Kindly take me. I mean, your lordship.
Want to file
affidavit. No, I do not want to file. If after the mediation, before 12 weeks.
Today
that is what I am saying.
Today you are making the statement.
After mediation, before 12 weeks.
Sir, that was you have assumed that it will fail.
My lord,
they have already
I will render my whole cooperation for the mediation.
Let us go there with an open mind.
Yes, absolutely, my lord. We'll all join there. Absolutely. Deeply obliged.
Obliged.
When you make the statement, sir, just
my lord. I was a bit apprehensive regarding time, nothing else, my lord. Deeply obliged.
Yes, sir.
Thank you. নেই 18 নেই।
Yes,
Next.
item 18. None for the petitioner. In the interest of justice, adverse orders are deferred. Let this matter be listed after 2 weeks.
Time for the private respondent, we are not served with a copy of the application. Further, Your Lordship, there is a matter against the similar party pending before the appellate side, which was mentioned on last week. Both the matter should be heard
This
analogously.
is original side practice, my lord. After, my lord, satisfactory service upon all the respondent, my lord, the matter appeared before your lordships. First, accordingly, my lord, all the respondent has been served. My lord, the allegation made by my learned friend is not correct, my lord.
Lordship,
And my lord, at my client's instance, there is no other writ application either original side or appellate side or any suit or before any tribunal is pending over this issue.
Lordship,
My
before
lord,
Your
this
Honor's
is-
bench only the matter is pending.
My lord, this is with regard to, my lord, I am a thika tenant, my lord, invested in a certain property, my lord, described here. My lord, what happened, my lord? I have, my lord, annexed, my lord, thika tenancy rent receipt original issued by the landlord. My lord, first annexure is that. My lord, what happened? I was running a bakery business, my lord, for long. And my lord, engaged, my lord, the private respondents, my lord, to look after since we were the minor at that point of time. My lord, what happened? That private respondent, by manufacturing one rent receipt, my lord, page 26. Page 26, in a manufactured rent receipt, they filed one title suit before the civil court, city civil court, and obtained an order of status quo against my client. And by dint of that order, they approached the KMC authorities to obtain a trade license, and they got it. That was the ex parte order. My lord, sir, my lord, we, my lord, entered appearance, and my lord, we filed application under Order 7, Rule 11 for rejection of claim because civil court had no jurisdiction because it is a thika property. So, my lord, Order 7, Rule 11 application was allowed. And when we approached the municipal corporation, that on the basis of the status quo order, you issued trade license in favor of this gentleman, my lord. They are not the, my lord, thika tenant, but now civil court, my lord, rejected their claim. And there was no, that order was accepted. And there was, against that, no appeal was preferred, my lord. And when I approached, my lord, that they are not doing anything on the basis of the rejection of claim. My lord, kindly have a look, my lord. First annexure, my lord. It will evident, my lord, starting from page 15. This is, my lord, the rent receipt issued by original land owner Taib Bhai Muhammad Hussain and Hashim Bhai Muhammad Hussain in favor of Tahidul Islam, my elder brother. My lord, kindly see, this is of the year 1980, and rent was, my lord, 100, tax was 35.80, and it was mentioned that a plot of land, 3 kathas, 1 chitax, 33 square feet. But kindly have a look chronologically, 15, page 16, 17, rent receipt in Xerox copy of the rent receipt in favor of Tahidul Islam, my elder brother. 18, 19. Now, let kindly see page 20, rent receipt in favor of my Mahidul Islam Malik, the writ petitioner before your lordships. Now, let kindly compare this rent receipt
And my lord, the private respondent claiming page 20.
You think I'm an expert?
No, certainly not. Description. Description. My lord, page 20, Mahidul Islam Molvi. My lord, now your lordship kindly see page 26 at once. Page 26, it is issued in favor of this private respondent that rent is 99. My lord, we are paying rent 110. How, my lord, I am putting question to myself, how the rent of the land reduced? It may increase. It is come 99. My lord, no land description yes there, my lord, kindly see. No land description was there. And in each my rent receipt, my lord, I relied on page 15 and onwards. Land description was there. And my lord, on the basis of this, my lord, they filed one title suit before the city civil court and obtained, my lord, order of status quo. My lord, kindly have a look, my lord. Page 58. 57, a letter of communication starts and order is a Xerox copy of the order 58. My lord, kindly see title suit number 1559 of 2023, order number 219 August 2023. My lord, this is an ad interim order expert. My lord, kindly straightway come. My lord, kindly come. Second paragraph, first, second, third. Going by. My lord, kindly have a look. Middle portion. Going by the materials on record and other documents annexed with the applications as well as in the plaint, it prima facie appears that the plaintiff are the lawful occupant of the suit property and they are running business legally. Hence, it becomes necessary to pass an order for protecting the rights of the plaintiffs. It is further found that the balance of convenience and inconvenience lies in favor of the plaintiffs because until the defendant are stopped by way of ad interim order, then the plaintiff will suffer immensely. Considering the principle governing the grant of injunction, it is found that ad interim order may be passed. Hence, it is directed that with regard to the nature and character of the premises as mentioned in the schedule has to be maintained an order of status quo to that effect. But by dint of this order, they approach the Kolkata Municipal Corporation to have a trade license. Now, my lord, kindly see what is the fate of their suit. My lord, I have, my lord, filed application under Order 7, Rule 11. And by dint of that, Order 7, Rule 11, that was allowed. And, my lord, we approached the corporation. My lord, kindly have a look, my lord. Page, my lord, 71, notice board. My lord, referring that title suit, my lord, kindly see notice board hanged by the private respondent. TS number 1559 of 2023, where they obtained the ad interim order of status quo. My lord, pending before Chief Judge, City Civil Court, Fresh, B, Bakery and others versus Mahidul Islam Malik and others. My lord, kindly see here, Fresh, B, Bakery. It's my business, my trade name. I used here. They add another E. My license was BE. He, my lord, by my lord mimicking my lord, my bakery, Fresh B Bakery. It sounds.
What are you arguing? Is it a trademark case?
No, trademark. No, not trademark. It is not trademark.
Is it passing off?
No, that is not. But what happened? They by pasting this and by submitting the ad interim order of status quo order, they obtained that. And moment I approached the court with Order 7 to 11 application, and that was allowed, then I approached the KMC authorities. But KMC authority is sitting tight. They are saying, you have also trade license, they are also having trade license. Well, you fight each other. Well, what is in view of section 199, my lord, it is true that municipal corporation having no right to decide title. But prima facie, on the basis of the document, they relied on the the order of the civil court, status quo order, and moment the order goes, my lord, so they had no right. So application without any basis, the claim found of the private is found false only on the basis of the one Xerox copy of the manufactured receipt and status quo order. This is not sufficient. When, my lord, I furnish the order of the fate of the order, they are not acting properly, my lord. They are sitting tight. When they got KMC got their application, become very active, and on getting my application, that their application was false on the basis of a fraudulent document, my lord, KMC is not doing anything, my lord. So I am not doing. I am suffering.
May I be permitted to mention before your lordship certain
Let him
facts?
speak.
Just
Are you in a hurry?
No, lordship.
I am not. Yes.
My lord, kindly have a look my prayer, my lord. And my first, my lord, your lordship kindly see my trade license. Page 23. Page 23. It is of 2023 to 2024. My lord, Messrs. Fresh B Bakery, B.E. Bakery, C holder names Maidul Islam Malli. My lord, got it, my lord. So this gentleman is before your lordship. He having trade license in respect of Fresh B Bakery, in respect of the particular premises. So, my lord, in single tenancy, Shika tenancy single, it is of petitioners. So he is not the tenant, or he is any other my lord, title or any other right over the said property. So how, my lord, the KMC issued trade license in favor of some stranger person who having no right over the property. My lord, 199 says, my lord, kindly have a look to 199 of the Act. One 99 says, my lord, every person engaged or intending to be engaged in any profession, trade or calling in Calcutta, as mentioned in Schedule 4, either by himself or by an agent or representative, shall obtain a certificate of enlistment or get the same renewed annually, as the case may be, from municipal commissioner upon presentation of an application in such form as may be specified by the municipal commissioner, together with such application fee. My lord, here application upon presentation of an application. So in that application, they have to, my lord, show that what is the status of the applicant against whom, in respect of whom he is seeking, my lord, license, trade license. So here the base document is, my lord, that manufactured rent receipt and, my lord, order of status quo passed by the civil court. If this is the main document, when, my lord, the order that suit is dismissed, my lord, owing to, my lord, lack of jurisdiction, it was rejected and no appeal was preferred. That was accepted by the plaintiff, here private respondent before your lordship. Then how, my lord, their claim, my lord, still lies? How, my lord, they continue the trade license? My lord, why it is questioned to myself, why the municipal authority is not, my lord, recalling the said trade license? When prima facie it is proved that they are having no license, no right, their suit has been dismissed and they accepted it. And they have no other document.
All right, are you done?
This is my.
Sit down. Sit down. Sit down, sir. Sit down. Sit down. Take your seat. Yes.
Lordship, the rent bill which he has placed, the genuineness of this rent bill are already in question because the case of forgery is pending against him. FIR has been lodged against them because he has been manufacturing this rent bill and produced those before the KMC. The trade license of which he's talking about, the original trade license was originated in the year 1982, which was in the name of Fresh B Bakery, which was my father. And the trade license which he has obtained currently, which is in the name of Fresh B, BE, has been produced by him in the year 2019. So I was the original owner of the licensee holder of that Fresh Bee Bakery. I have been running business therein from.
Your son of Muhammad.
I am the son of Muhammad Ghani, the original Thika tenant as well as the original license holder.
Yes.
We are running partnership business over there from last 50 years.
Yes.
Furthermore, Your Lordship, there are many other documents which I need to place before you. Give us an opportunity, ask them to give us a copy of the application that has not been served to me. This is not the first application they have made herein. They have filed several writ applications before this court, and this has been rejected by the bench of Tirthankar Ghosh as well, the Justice Tirthankar Ghosh. There were police and action matters pending filed by them. That has also been rejected. They have gone to the court below as well. That has also been rejected. So I need to place every document before Your Honor if given an opportunity.
What is the other matter which is pending?
Lordship, I have also filed one writ application against the KMC authority. Lordship, we have served them the copy. We have not made them the party therein because that was again the KMC and us, because we have made them, requested them several times to cancel their application because they could not produce any document at the time of hearing. In the matter is still going in the KMC. They could not produce any document then, but still their license has been continuing. And Lordship, his status is he's just one of the occupier of the bakery, confectionery, which is a shop room therein. He's not the holder of the bakery. The bakery is still run by these opposite parties and his other partners.
The order of the Thika tenancy, 15-6 order.
Lordship, we do have every copy, Lordship, but I could not produce it here. And Lordship, one more thing he has stated before Your Honor that it was only after the passing of the title suit order that we could obtain the license. That is totally vague. The license was existing since the year 1989 or prior to that. It was not obtained after the order.
Mr. Ghosh.
Only submitting under the submission of my lord Mr. Buddha is sufficient to dismiss the writ petition because I find a lot of my lord the disputed issues are here, suits are pending, right of tenancy, right of possession between the two parcels are there. He is claiming that he has inherited a ticket tenancy. He says that my landlord's client has inherited a tenancy. All this my lord in a way when the suit is pending and other proceeding is pending, that my lord cannot be resolved simply by taking advantage that someone has obtained a certificate of enlistment. The certificate of enlistment, the moment the right of established by the civil or competent forum, it will automatically go. It will not stand.
I am paying for that, my lord, only. Everything, my lord.
File your affidavit, we will dismiss it.
My lord, claim of the private respondent is all verbally. But there is no suit is pending, and she is claiming everything is with him. My lord, no document.
Give a.
At my instance, my lord, nothing is pending, my lord. Yes, we prefer one writ application against police inaction.
Not one, there were three.
Just
that application, that is, my lord, since my lord, they are despite complaint.
Where have you mentioned? Where have you mentioned here? Where have you mentioned that you had filed a writ petition for?
Of this application that was taken.
No, Lordship.
No, where have that was filed earlier or after this?
Before, much prior to this, Lordship, it is a vague submission, Your Lordship. It was done in the month of September last year. Thereafter, March this year.
My lord, that is
you
put all action, my lord, and
I'll put the order and the status as well, Your Lordship.
For the property, my lord.
All right, take down.
Just today.
Sit down, sir. Take down.
Lordship, we are still the Thika tenant.
The thing is, my lord, verbally.
Take down. The petitioner.
Sir,
I've heard you.
No, nothing was served upon it.
Supply a copy. Supply a copy.
No problem. But the claim is vague.
Sir, supply a copy.
Yes, definitely.
And listen, Mr. Poddar, just because your client is standing there.
No. I asked him whether.
Don't.
It's my client.
Don't try to impress your client.
Client, not client.
Please sit down. The more indulgence is given to you, you are trying to take the court for a ride.
I'm sorry, he's not my client. He's
Let this matter be listed after 4 weeks.
My lord.
Enough is enough. I've been very patient. I've been extremely patient with you.
That is my misfortune, my lord.
You don't know how to address the court. I patiently heard you.
Yes. I am bowed down to your lordship. Your lordship.
Enough is enough.
I'm sorry, my lord. He is not my client. For that is nice.
No way to behave. And not with this court. Write some. Patiently, I've been hearing you. Right? They stunt somewhere else, not here. The petitioner, comma, by way of the present writ petition, comma, is assailing the trade license issued in favor of respond number 5 in respect of premises number T9, Nawab Abdul Latif Street, Calcutta, for operating a business under the name and style of inverted comma में करना fresh BE, B capital E, BE Bakery, inverted comma close, full stop. The petitioner contends that the said trade license was granted on the basis of forged rent receipts purportedly issued by the landlord in favor of respond number 5 in and around December 1982. Full stop. It is the case of the petitioner that he is the lawful thika tenant of the said premises. Full stop. The petitioner's late uncle, comma, G.D. What was the name?
Muhammad Ghani.
S.K. Muhammad Ghani, comma, was operating a bakery from the said premises under the name Fresh B Bakery, same, comma, on behalf of the petitioner. Full stop. Upon the demise of his uncle, comma, the petitioner claims to have taken over the business. Full stop. Claims to have taken over the business and has been running the same ever since. Full stop. The petitioner alleges that respond number 5, comma, who is the son of late Muhammad Ghani, comma, fabricated rent receipts.
Lordship, that is our contention, Your Lordship. The private respondent's contention. I am for the private respondent.
Or they have fabricated the rent receipts.
The petitioners have fabricated the rent receipt against which FIR is pending.
Sorry, the respondent number 5 states that the petitioners have, the private respondent number 5 states that the petitioners have fabricated the rent receipts in connivance with the landlord, and that cases are pending.
Cases are pending, Your Lordship, before the New Market PS. FIR has already been filed.
And that a criminal complaint, an FIR has been lodged.
FIR is there.
Criminal complaint and an FIR complaint showed. An FIR has,
and the complainant was the KMC itself.
And an FIR has been lodged against the petitioner. Full stop. Learned counsel for the respondent KMC states that the trade license has been issued on the order dated 15/6/2023, passed by the Thika controller.
Lordship.
Passed by the Thika controller, which has been challenged in OA number 1286 of 2024, which is still pending adjudication. Full stop. Learned counsel for the respondent KMC seeks and is granted 4 weeks time to file his affidavit in opposition. Learned counsel for the private respondent number 5 seeks and is granted 4 weeks time to file.
Lordship, one more indulgence, Your Lordship. If the appellate side matter which is pending in the same cause of action could be taken together.
You have not made him a party. You have not made him a party.
We have not made him party.
You should have made him a party.
It was filed earlier than.
File affidavit in opposition. Reply to the same, if any, within 2 weeks thereafter. List after 8 weeks. List after 8 weeks.
Grateful, Lordship. Lordship, I'll ask them to please serve us with the copy of the application.
Give a copy of the petition.
When
8 weeks. Give a copy of the petition.
Grateful, Lordship.
I'll come back in 5 minutes. Yes.
20 lots of am for the. Lordship, the property is a Thika tenant property.
Yes.
Lordship, the allegation of unauthorized construction.
Yes.
So kindly come my complaint. Starts from page 20.
You stay nearby? Where do you stay?
Lordship, petitioner is the neighbor. No, sorry, not that.
What is your interest in this property?
Madam, sees page 3, my lord. They
No,
says
petitioner is
that it is
residing
a
at
public
20
interest litigation.
26A,
Page 3.
Raja Rammohan Saroni, Narkel Danga.
7,09,000 is the petitioner's pin, and the property is at 7,11,000. 7,11,000 is the property. It is said that for the interest of the public at large.
Where do you reading?
That is a page 3, para 1, my lord. Page 3, para 1. They have admitted it. So it should be a
The
public.
various type of properties like Thika tenancy property and that Kolkata Thika control and Khas Mahal properties, the same was vested to the state of West Bengal, like the property of the premises where petitioner is residing. Other properties mostly are Thika tenancy properties. And it has been controlled and managed by the West Bengal through Thika controller Kolkata.
So this is a public interest litigation. It's a public interest litigation.
So let's kindly come paragraph 3 again.
No, I'm asking you, if you look at it, you have filed this petition for enforcement of rights or interest of public at large against the arbitrary and preserving executive action.
And the property is also situated at a distant place, my lord.
And you are saying that there are various types of properties.
Yes.
Like of Thika tenanted property.
Yes.
And Khas Mahal property.
Yes.
And the same are vested in the state of West Bengal.
Yes.
Like the premises of the petitioner.
Where the petitioner residing.
Yes.
And other properties mostly are Lordship, this is the first thing, Lordship, I have a right to raise any objection against the illegal construction.
You can file a public
held by this different court that
Yes.
even I'm not residing with this place, I'm residing beyond the jurisdiction, I can raise the complaint regarding unauthorized construction. Lordship, kindly give me 1 day time, I'll produce all these relevant judgments which has been passed by this Honorable High Court.
Absolutely.
That even the persons who is not directly affected, not within the vicinity of the Lordship.
No, but why one property? Why not the entire all the properties which have been constructed? Why this particular property? What is your interest in this particular property? Why this one?
I am one of the
This is the only unauthorized construction in this area?
That's certainly.
Then why this property?
Now, Lordship, this is because rightly or wrongly, Lordship, this is the the allegation is unauthorized construction is going on.
Sir, I admit your locus. I am asking, is this the only property where unauthorized construction is going on?
No, that is not. That is
What is your interest in this property? Why is this petitioner? You might not know. Ask your client what is his interest in this particular property. Why has he chosen only this property? And can he file an affidavit stating that there are no unauthorized construction in the vicinity and this is the only unauthorized construction?
This is not my knowledge. This is not.
Please find out.
Only knowledge that there is an unauthorized construction is going on. I file this.
You know what I am saying? It's not putting on you. Ask your client. All right? Please ask your client.
They have admitted that various types of Thika tenants properties in the para 3.
I'll give him an opportunity.
Well,
Lordship, kindly.
Sir, I'm giving you an opportunity.
Yes.
Please. I'm sure you understand what is falling from the court. All right? Use your wisdom to find out what is the reason. All right?
File a supplementary affidavit.
I'm not saying anything. take instruction, come back. We'll see that. At the request of the learned next week, not today.
None.
What's my affidavit service?
Give it back. I hope you understand what I'm saying.
If an order be passed to that effect.
Or at the request of the learned counsel of the petition, let this matter be listed on 7th of August.
Right.
Twenty-one, my lord.
My lord, I am
We
appearing
have
on
been
behalf of the
instructed to
petition.
appear on behalf of the Kolkata Municipal Corporation, my lord. My lord, let a copy be served, my lord.
My lord, we have served, again we will give.
Well,
There is no way. But my
let a
lord, the
copy be
problem
served.
is that
Otherwise, we
there
will
is a
take instruction, my lord.
Unauthorized construction.
yes, my lord, the unauthorized construction.
Give a copy.
No issue at all.
Give a copy, then only they can take instruction.
Grateful, my lord.
Not this week, next week.
Grateful, my lord. Capital,
আমি একটা লিখে আমি বলতে ভুলে
But the building is a very dilapidated building. The corporation has already issued a notice under 411. Thereafter, it has been demolition contractor have been appointed. Now, my lord, they have given us a hearing under 412 capital A, which is a special provision
Yes.
where they give an option.
Yes.
In case of a dilapidated, first they declare it as a condemned building, and then an option is given that you can apply for a sanctioned building plan for reconstruction with provision for rehabilitation of the tenant. Obviously, my lord, that has to be done. So, my lord, that order is there. Condemned building, it has been declared. Now we have applied to the corporation in terms of that option for the purpose of reconstruction. Upon submitting, my lord, and my lord, a sanction plan and all other, my lord, yes, we have already done that, my lord. Now the problem is, my lord, the last letter which has come from them, kindly come to page 93.
Nine.
193, I'm sorry. Volume 2. Before that, my lord, if I may kindly give me a moment, I show your lordship that order at page 92. Order under section 412, capital A. Page 92, volume 1. Kindly see, my lord, the ordering portion. Upon hearing the, has your lordship got it?
Yes.
Upon hearing all the parties, after perusing records and reports submitted by the executive engineer, I am of the view that existing building is declared as a condemned building, as per report of building department, taking in account the safety of the inmates and public in general. Then, whereas the existing building premises number such and such has been declared as a condemned building by this department notice dated such and such under 412A, whereas the owners and tenants occupiers are to vacate the building within 30 days from the date of service of notice for safety and security of the inmates. Then, page 93. The existing building is to be demolished by the owner of the premises at his own cost and risk under supervision of an empaneled structural engineer to avoid an accidental hazard. Then, next paragraph. The owner of the captured premises is directed to give proper rehabilitation to the tenant occupiers of premises and to provide equivalent space to all the tenants after construction of new building at premises number 197. Owners are hereby offered an option for reconstruction of the building in accordance with the plan to be sanctioned by the corporation as expeditious as possible by providing floor area to accommodate to erstwhile tenants occupiers an additional floor required for recovery of expenses. Now I have been requested to give a proposed plan. That also I have done, my lord. Kindly see page 94. Page 94, volume 2. I have submitted the plan proposal.
Page
94, annexure P8, volume 2. Date ta kothay pabu?
Yes.
Kindly see page 94.
Page 100. Page 100.
Pursuant to order under 412A, I am hereby submitting the plan proposal showing rehabilitation of tenant occupier.
Yes.
Lordship will get the date at page 100, but page from 95 onwards, your Lordship will see my application in the prescribed format.
Yes.
Kindly see page 96,
Yes.
occupancy details. I have mentioned about every tenant. Then, my lord, area statement of tenant.
And none of the tenants have any issue, right?
Point is, my lord, they are not giving the formal no objection. And as a result whereof, my lord, the sanction is not being processed. Now, my lord, I submit, my lord, I have given to the corporation the details, even the undertaking has been given, my lord. Kindly see, I have given a register undertaking at page 123. So this is the requirement which I am in a position to discharge. The document which is coming from them, that is not within my control. KMC undertaking such and such.
Rehabilitation of that happens.
Yes.
Owners declare they will not evict any tenant if it necessary to remove owners under provide them with identical area in or by mutual arrangement for the purpose of reconstruction. And my lord, the proposed plan which I have submitted, there I have indicated the proposed area to be given to the tenant. Now, my lord, they are insisting on this, my lord, page 193, for which I have come here. In connection to your submitted file for sanction under 142 of the building rule, it requires no objection certificate from the existing 11 tenant. Well, that is a condition which is not dependent upon me. I can say that I will give a declaration for rehabilitation. I will not evict. I am showing in the sanction plan the area which I will give. Now you are insisting upon a document which is to be, and this document now is used as a mode of exploitation by the tenant. Now, but I say only this.
It's the same. When even in Delhi, when you want to construct a floor, you have to have NOC from the other floor owners.
Yes.
And 90% of the times, they don't give you NOC.
That is the problem.
So this exists everywhere.
Yes, but here
in different forms.
Yes, I bow down to your lordship. But this 412 capital A, kindly have a look at the section 1. This is a special provision. 412 was there. This has been brought in by way of amendment. 412 says if the building is dangerous, corporation feels, then they will issue 412 notice, nobody will occupy the building. That a further step has been brought in by 12A, where we will declare the building as condemned. Now, once it is declared as condemned, then no one can occupy it. This has to be inserted, this has to be enforced by the corporation.
No.
Whether they will, now, my lord, this issue your lordship can decide on affidavit. Whether the corporation can insist upon NOC after I have given the registered declaration. But insofar as the declaration of the building is condemned, the tenants can have no say. So therefore, it cannot be the stand of the corporation that the building is declared condemned, but you continue to occupy it. And when it will fall down in this weather,
I think it has happened day before.
Yes,
I was
yes.
reading in the newspaper, two
Yes,
buildings
yes,
have collapsed.
it has collapsed. And now, if a mishap occurs, the police will come on me. So, that is why I say that today the corporation should just seal the building. And therefore, the tenant cannot occupy it also. So, the statutory
Show me
provision.
that sealing provision if the building is declared to be dangerous. Where's the sealing provision?
Kindly see the 412 and 412A, the difference. First, let us come to 411. 411 notice was hereby given. That is already on record. Then 412. So it is stage by stage. First, it is order removal of dangerous building. 411 notice here has been given on July 2021. In this case, at page 70, your lordship will get it. So thereafter, just kindly take page 71.
Page 71.
Yes, volume 1. After the 411 notice, kindly see, they are instructing a contractor to engage the caution board. Building at the above premises lying in dilapidated condition and may collapse in future. Department has taken action under 411. Now, on the basis of approval, appropriate authority and as per order, it is hereby directed to you to fix up the caution board with immediate effect, declaring the building dangerous. The building at the above premises lying in a dilapidated may cause collapse in the future. Department has taken action. You are therefore directed to fix up caution board under 411(2). So this also has been done. I'll show. Then your lordship will kindly see, they have even intimated at page 72 to the officer in charge. Page 72. Neither owner nor occupiers took any initiative to secure the insecure parts of the building, so a dangerous building board has been fixed by this department. Condition of the building is in a much damaged state and may crumble at any time, which may cause catastrophe and loss of life, they are saying. This is 7th November 2022. Then, my lord, kindly come to page 73. This is a work order for demolition given by the corporation. Again to that contractor. Second paragraph, your lordship will see. As per order of Deputy CE Building, dated, sir, you are therefore being engaged as demolition contractor for the aforesaid demolition to be undertaken with immediate effect. This is on December 2022. Thereafter comes the order under 412A. So now your lordship will kindly see 412 once. Provision. The municipal commissioner may by order in writing direct that any building which in his opinion is in a dangerous condition, which opinion has been recorded in this 411 and the so many correspondence, or is not provided with sufficient means of egress, that is not our case, or is occupied in contravention 396, not our case, be vacated forthwith, or within such period may be specified in the order. Then subsection 2. If any person fails to vacate the building in pursuance of such order, the municipal commissioner may direct any police officer to remove such person from the building, and the police officer shall comply with such direction. Here you have given an order, you have given a notice to the police station that we have declared it dangerous. Catastrophe may occur. Then, there is a power for reinstatement also under subsection 3. Now, 412A has come in 2017. Power to declare building or any part thereof condemned and to order demolition of such building. Now, therefore, this demolition order has already been passed. Once you have declared the building the condemned building, 412, the order which has been passed in my case is 412A, capital A, subrule 3, subsection 3, which says, simultaneously with the making of declaration under clause 2, that is, copy of the declaration under clause 1 shall be served of the owner and occupants who are recorded in the records as also pasted on the outdoor of the building, requiring the owner and occupier to vacate the premises. Thereafter, simultaneously, corporation will serve a notice on the owner or owners and paste it on the outdoor building, providing an option to the owner or owners to reconstruct the building according to the plan to be sanctioned. So, my lord, this order, which I showed your lordship, presupposes an order under 1 and 2. Then 3 comes. So therefore, my lord, my submission before your lordship is, we could have straight away acted in terms of 3. I have given the sanction plan, reconstruction could have started upon demolition. But that is not being done because the sanction plan has not come, because they are insisting upon no objection from the tenant. So therefore, my lord, that issue which I raise, your lordship will decide whether once I give a registered declaration, I submit a sanction plan showing rehabilitation, still whether I should be made dependent upon an act of the tenant. That is number 1. But for the time being, in view of the corporation stand, the building has to be vacated. Well, your lordship will kindly see the photographs. I do not know whether it may happen anytime. Kindly see 84. I think lordship has been given colored photographs. Kindly have a look. Page 84. Page 77, all from 77 onwards, your lordship can just see. 82, these are the interiors. 81, 77. So, my lord, as an interim order today, my lord, I seek this direction, my lord. The corporation must take steps for having the property vacated. Otherwise, my lord, I will be in threat. Some eviction suits are also pending, my lord. But this is, I am not saying that this provision of the Corporation Act is not a purpose of eviction. I am saying that I am reinstating you.
Yes.
And my lord, this is to enforce the order under 412A. This is not a separate case where a building with tenant I have applied for plan, where this no objection has to be given. Here this their order.
Yes.
My lord. But may I refer 412A?
Yes.
My lord, if you lords kindly take once 412A, that my lord, that will show that my lord, may I read it?
Yes.
Notwithstanding anything contrary to in this act or in any other law for the time being in force or in any agreement, custom or usage or in any degree, judgment, decision, award, etc., where it appears to the municipal commissioner that demolition of a dangerous building under section 411 will cause hardship to the person in occupation of such building or may not be conducive to the public interest in the urban area suffering from acute shortage of accommodation. My lord, 412A basically actually presupposes 411 and thereafter 412 and 12A. 12A purpose of the 412A is for the tenant or occupier, your lordship. That is I am showing. And my lord, the second thing, I have one report whereby, my lord, I am referring this report, my lord, one report which is actually gist up of the issue. And my lord, I am again, I want to refer rule 142 and 43.
Yes.
Rule 142, if your lordship kindly take rule 142, that will show, my lord, 142, that is sub-rule 3. Every application.
Wait, one.
My lord, 142, old and insecure building.
Rule then.
Building rule probably.
Yes. Yes, 142.
142, my lord, kindly take, my lord, sub-rule 3. Every application for availing relaxation under sub-rule 1, the petitioners applied for actually availing the extra areas under rule 142. And then, my lord, has to be accompanied with the documentary evidence of the tenants of the existing building signifying their consent to the demolition thereof.
Yes.
So, my lord, out of probably, my lord, my report says the 9 number of tenants are not agree. My lord, that is there. My lord, then I may refer next rule, maintenance of the building. If you also kindly read 143. My lord, petitioner's case is this building is nearly 50 or 100 years old. My lord, for all buildings older than 40 years, the owner of the building shall have to get the building inspected by a structural engineer within a year from a date of coming.
All this is not applicable,
This is
Mr.
applicable in the sense, my lord, because why I am reading.
Thus, you have declared the building to be dangerous.
That building has dangerous, but 412A, your lordship sees, that is for the purpose of benefit. 142 rule benefit is given.
Benefit will be
9
given.
persons, my lord, who are the
Benefit will be given. You start the.
My lord, I am for the respondent number 7, 8, and 9, my lord. They are the, my lord, they are the lawful tenants, my lord.
Yes.
The building has 2 parts. In the first part, there are series of sub room, and then there is a gap of 10 feet. My lord, and after the gap of 10 feet, next part of the building exists. I am told that the back portion is already started by work of demolition has been started by the owner, and our part is totally distinct, and that is quite good, my lord. Kindly see, my friend has shown the photograph. This portion of the photograph has not been shown where the sub room exists, and this portion is totally disconnected with the back portion, my lord. My lord, my lord, we are, my lord, agreeable to repair the same at our own cost, subject to approval of the KMC, my lord. My lord, they intentionally, my lord, with a view to, my lord, evict the tenant. Already eviction suit has been filed. This process has been initiated. My lord, this is to be, my lord, I require to file opposition to the application. And my lord, if your lordship thereafter, after hearing me, my lord, if your lordship thinks that matter to be referred to the mediator, that may be also referred, my lord, because so many aspects are to be decided. Whether yes, whether yes,
they will get a new space.
Whether where you are giving place, within how much time you will give me place, all those matters to be settled first.
Yes.
Then question will arise. So if these matters cannot be, my lord, overnight. It cannot say. My lord, he is only interested to demolish the building and construct the new building. My lord, we will be nowhere. We will be nowhere. My lord, there should be everything, my lord, specified.
But since it is coming and offer is
My lord, we are, my lord,
suggest
this is an indirect process, my lord, of eviction of the tenant.
Yeah, may I suggest this, Lord? Since my learned friend is taking an approach that they are amenable to talks, but your lordship will keep my writ petition pending. Let us sit together once, because we have made several attempts. Ultimately, I had to come to your lordship.
So I'll refer you to mediation. Go before the mediator.
Yes.
Yes, my lord.
Kindly.
Send.
And let all the but
All of you go before the
yes,
mediator.
yes. Lordship will allow all the tenants to go. Then, my lord, your lordship will keep the writ petition pending. We'll come back.
My lord, I do not know whether all the owners have been, shop owners have been made parties or not.
Yes, we have made all.
আমি 7-8 নয়।
At the request of the parties to find an amicable settlement.
May I come? May I take your lordship's kind?
Yes.
I take your lordship's kind leave, my lord.
Yes, certainly.
Just
But that is agreeable.
Lordship will keep it pending.
Yes.
Let it appear after 3 weeks. Let the mediation report come, my lord. HON'BLE.
At the request of the parties, let this matter be referred to the High Court mediation cell
I am for the statement.
for an amicable settlement of the dispute between the parties. Let this matter be listed before the court after 6 weeks. After 6 weeks.
My report is kept with the record.
My lord, may I
AMC report I have.
I'm not keeping any additional.
I am not.
Lordship, may we be
back.
favored with a copy of the report which
No, I'm not keeping any report. We'll see it after. This is no report.
My-
This is neither here nor there.
I filed the affidavit of service. Your
These kind of reports are not to be kept on record.
affidavit of service.
Affidavit of service taken on record.
So all of the tenants have been made a party to the writ petition, Your Lordship. As my learned senior friend has submitted that 9 tenants have been raising objections, we have made 10 a party to this.
Take the order to the mediation cell and
Great.
see what.
Great. I'm so grateful to you, Lordship. You can leave me, no?
Please, Sri, my lord, I appear for the petitioner. This is that matter. Lordship will recall La Martiniere School had preferred a writ petition seeking for a direction to cause necessary construction work. Oh, I'm led by Mr. Sankalp Narayan. He's appearing virtually, my lord.
May it please your lordships. Hello, am I audible?
Yes.
Hello, in this case, an order was passed by this honorable court on the 22nd of May. This was in respect of certain repairs which we were seeking in the institution. Your lordships had directed the council appearing for the KMC to file a report on the next date of hearing. Well, this was an order dated 22nd of May. Now, well, since the matter was urgent, we filed an appeal before the division bench, which is APOT 157 of 2025, which was heard during the summer vacation by the honorable division bench.
Yes.
Whereas various orders were passed on a day-to-day basis, and ultimately the appeal was disposed of with a judgment dated 13th of June 2025. Whereas there the division bench directed, gave us all the permissions to ensure repairing of the urgent repairs which were to be made, and further directed that a report be filed before this particular in this pending writ petition pursuant to the orders of the division bench. So, whereas my learned friend would provide a copy to your lordships of the final judgment of the division bench. This is dated 13th of June 2000,
We have already, Mr. Narayan.
25,
Yes.
my lord. Whereas if your lordships would have the penultimate paragraph, this is paragraph dated, paragraph number 9 of the judgment and order dated 13th of June 2025. Does the lordships have that, paragraph 9?
Yes.
Now, after this order dated 13th of June, my lords, we moved a modification application, which is the next order dated 19th of June 2025. We were seeking slight modification in the final judgment of the Honorable Division Bench. And at paragraph 4 of that order, the Division Bench specifically stated that we may proceed with the urgent repairs, but that will be under the supervision of the Heritage Commissioner and the structural engineer appointed and nominated by the Kolkata Municipal Corporation. Because that has been mentioned, the names of the Heritage Conservation Architect and the structural engineer has been mentioned. Now, as on date, what has happened is that we have been undertaking the repairs under the supervision of the Kolkata Municipal Corporation. So, as on date, we do not have any grievance pursuant to the orders passed by the Honorable Division Bench. So, my lords, either the corporation may be directed to file a report in the matter to update your lordships with the progress, or, my lords, we may be permitted to file an affidavit informing your lordships as to what has been happening pursuant to the orders of the division bench.
Yes, Mr. Ghosh.
The scope of this dispute was very limited. Only he came to this court because earlier petition was also pending before my lord, Mr. Jasti Aniruddha Roy. That is also assigned before his lordship on the same issue. But he pleaded an urgency regarding certain works to be conducted. Then your lordship was pleased not to intervene because of the other cases are pending. They moved before the vacation bench. And we reported that situation has not come in a day. because it's a long drawn, because they cannot be permitted to do the work without following the legal procedures. And then the court asked us to hold a meeting regarding the Heritage Conservation Committee inspection. Then we submitted a report. On looking over the submission of the report, then the court said that these are the 4 items Your Lordship has mentioned, and 13th June order. The 4 items have been mentioned by the committee, Heritage Conservation Committee. Then the court directed that so far as the repairing or certain works which has been mentioned, that is to be under the supervision of the structural engineers and the conservation architect to be nominated. That has been done. Now, in view of the order of the division bench, the report to be filed to Your Lordship's court, my lord, from time to time. After the report comes from the structural engineer and also the conservation architect, will be collecting from those the persons regarding the supervision of the works, how much it is in progress. The time has been given from the date of appointment, 45 days. That time has not yet reached. Well, I will inquire of that, how much progress has been done and how the work is continuing. And that is then Your Lordship will consider.
Because I may just, subject to Your Lordship, I may just suggest one more thing. Well, as on date and pursuant to the orders of the division bench, there exists no problem. The problem has been solved and the repairing work is underway. So, if my learned friend would agree, we may be permitted to withdraw this writ petition at this stage. If we've got any problem subsequently with the corporation.
Difficult would be, my lord, that because still same application is pending before another bench on the same issue.
That's a separate cause of action, if I may inform.
That's the same issue. 2 petitions are there. One is relating to regarding the construction part. And, my lord, the actions being taken by us, my lord, regarding the making of the heritage building, my lord, without obtaining the permission. Certain the actions have been taken. If we get that application before the other bench, because this matter to be heard by Your Lordship in terms of the division bench, and if the other court, my lord,
he wants to withdraw it, what is your difficulty?
Because the court has said on the report to be submitted, because of that, or rather, my lord, the case to be withdrawn by them. And this matter to be heard by Your Lordship, because the court has directed before, in this connection, the appeal was taken out.
The court has only directed, you are already, they are not.
But if they do not want, I cannot stand in the way. But I submit on the same issue that another court, but I'll be very good. I'll be submitting the same thing before the other bench, my lord.
Learned counsel for the petition seeks to withdraw the present writ petition. The same is dismissed as withdrawn.
Well, our Lordships may just indicate at this stage, because we might have some problem. So our Lordships may just indicate at this stage we may be permitted to withdraw. That would suffice, my lord. That's the only prayer.
Learned counsel for the petitioner at this stage wishes to withdraw the present writ petition. At this stage,
I'm great.
Withdraw the present writ petition. The same is dismissed as withdrawn.
I'm grateful, my lord. Much obliged.
Deeply obliged, my lord.
Item number 24, Lordship. I have instruction to appear this matter. One copy may be served.
Copy has already been served, my lord.
Give one more.
Very well.
Yes.
What happened, my lord, kindly comes to, my lord, page 28.
Page
28, annexure P2. My lord, kindly see this is the, my lord, order of, my lord, retention. Kindly comes to the operating portion at page 29 of the private respondent. I do not find justified reason to demolish the existing structure, existing building, where the construction work has been taken to secure the old.
Where are you reading this?
28, my lord. Continuation is at 29. I'm pressing
details of unauthorized construction. Page 28.
28.
Demolition.
Yes.
Yes. Where are you reading?
No. He was permitted. The private respondents were permitted to retain. I was placing that 29. The last part. Measurements are given. Kindly see. I do not find justified reason to demolition the small existing building where the construction work has been taken up to secure the old dilapidated structure. I am inclined to pass order to retain the structure building replacement to at asbestos shed to RCC slab on payment of fees of rupees under section 401 to be paid within 30 days for the date of communication of failing which action will be taken by by the department. The sketch map will part and parcel of the order. Any person, then provision of appeal is given. But this was done. Therefore, what was, my lord, permitted to be written is the old structure with with RCC slab. That was, my lord, the permitted to be retained. Now, my lord, what they have done now kindly comes to page 44. My building is the just adjacent building. They have demolished it without plan. My lord, construction is going on. And my lord, my building, they are building now, my lord, it's more apparent, my lord, from 45, page 45, kindly see, it is almost touching the, my lord, walls of my building. The adjacent building is my building. They were only permitted to retain. Now, my lord, this construction is being raised without plan. Now, my lord, almost, my lord, touching, my lord, the cantilever of my building. Entire new floor. They were only permitted to retain the RCC structure subject to payment of fees.
It's already completed.
Almost in the process of, we filed it, my lord, filed this, my lord, long back. It was running in the list.
Yes, Mr. Das.
Junior, for a copy. Day after tomorrow.
Why you never get copies?
In my
Mr. Das never gets copies.
my lord.
I'll serve him another copy.
And
Give a copy, take instruction, we'll have it next week.
Lordship.
Copy party.
We'll make it not today, we'll have it next week.
So, my lord, kindly passes an order that let them, my lord, inspect and come with a report.
The report, they can't do it unless until you give him a copy. We'll have it next week, not today.
Well, I'll submit by course of the day.
So we'll have it next week. We'll pass an order whereby either they decide your representation or they file a report, up to you.
Happy.
But you have to give them a copy.
Very well.
Next Thursday.
Well, it may retain its position in the list, my lord. Otherwise, if it goes down, I'm good.
We'll dispose it off, whatever way, whichever way you want it.
Yes, definitely.
We'll dispose it off. This has to go. The unauthorized construction has to go.
My lord, they were only permitted to retain the RCC slab. Now, my lord, the entire floor is coming up.
And don't serve Mr. Das by email. He doesn't open email.
Physical copy.
Give him a physical copy.
My lord. Bill name. Well, I appear for the Calcutta Municipal Corporation.
Lordship, I am for the petitioner. The petitioner appointed initially to the post of sub-assistant engineer on 30th July 1996, subsequently promoted to the post of assistant engineer. With the petitioner made no application for getting no objection from the KNC authority for completing his BTech degree and ME Geotechnical Engineering. After obtaining the no objection certificate from the authority concerned, he has completed his BTech degree and ME Geotechnical Engineering degree. But at the time of preparing of gradation,
Service matters also, there's no, it doesn't go to Central Administrative Tribunal.
No. KMC service melody.
Not notified.
KMC,
It's the state service.
KMC.
Yes, madam.
The respondent authority did not clubbing the BTech and ME Geotechnical Engineering degree of the petitioner at the time of preparation of the gradation list, Lordship. Therefore, he could not be get his promotional benefit, Lordship. He is entitled to get the scale of pay of executive engineer since 1st February 2020 and promotion from 14 January 2025, Lordship. That was not considered, Lordship. The petitioner made several representations for clubbing his degree before the respondent authority also. That was not also considered, Lordship. At the time of preparation of gradation list, Lordship, on 1st February 2011, Lordship, 6 numbers of assistant engineer were upgraded to the post of assistant engineer, Lordship. Lordship, I am bringing your Lordship's kind attention to the annexure and stern at paragraph 7-8 lordship. Paragraph 8 lordship. 6 assistant engineer was promoted lordship, but the petitioner's name was at serial number 161 lordship. At annexure P4 lordship, circular dated 4 February 2011 lordship. The petitioner's BTech degree was clerk. Subsequently, at the time of preparing of gradation list, the petitioner's degree was not included lordship. As per the Apex Court judgment lordship, the petitioner was appeared for validation of his degree lordship and succeeded in that examination also lordship. That 6 number of assistant engineer was upgraded. Their degree was not cancelled, but the petitioner's degree was not clerk lordship. The petitioner made objection.
What is she saying?
Well, first of all, my lord, that he wants, my lord, the certain degree he has obtained, and for
Yes.
that degree, my lord, he wants certain benefits. But so far as that is concerned, my lord, whether the genuineness of the certificate, for which, my lord, we have written a letter to the appropriate authority for verification of the genuineness, that has not come to me. But moreover, your lordship can see, my lord, he is asking for, your lordship can come to page, my lord, 6, paragraph 11. He is asking for modification of the gradation list which was prepared, my lord, 5th July 2021. For whatever the reasons. Now, my lord, there is a case before this honorable court with regard to this particular gradation list. And that gradation list was, my lord, set aside by the honorable single bench. Then, my lord, on the basis of the order of the single bench, a further gradation list was modified, and that was published in 2024. Then, my lord, the original order of the single bench, that was appealed from 4 appeals were preferred before the division bench. Division bench, my lord, ultimately, my lord, passed a direction regarding the supernumerary post holders that they cannot give their birth from the date of holding the post of supernumerary post. They should be given birth or the promotion, their seniority to be counted from the date of actual absorbment or the birth when they are coming to that position. Therefore, their position has been now in the lower position because of their situation. But the division bench has held that 5th July 2021 gradation list, that final list shall prevail. And consequently, the other the gradation list which was prepared in 2024, that had also been cancelled. Now, the Supreme Court was moved by some of the parties. The Supreme Court also did not find anything wrong in the judgment of the division bench. Therefore, that has been cancelled. In another set of the litigants, my lord, filed a earlier writ petition. They say that the order of the division bench regarding that gradation list to be modified. Then the division bench, single bench rejected that application. Obviously, because the division bench ordered the single bench cannot be. Then the appeal was taken out. Then appeal court says that how the litigants will come to the court, my lord, for questioning about the gradation list which has been finally prepared, and that too has been upheld. Therefore, whatever the reasons with them for for modification of the position or something, any other thing, they had to take out any other mode, where from they can get that modification. But as on this day, 5th July 2020, and the final gradation of the assistant engineer, that cannot be altered at all. As so far as that their qualification is concerned, my lord, the acquiring of certain degree, for that we have approached the appropriate authority, wrote a letter for verification, veracity of that genuineness of the certificate. That has not yet received by us. If that information comes, if something to be done on the face of the order of the division bench regarding that the final gradation of 5th July, if anything to be done, then I could do. As on this, nothing could be done.
So,
Then
madam,
Lordship kindly give direction to the last respondent authorities, Lordship. I have made him party for the certificate, Lordship, whether the certificate is validated or not, that could be responded by that authority.
Yes, yes, I have read that. This is the letter.
Lordship. Yes, Lordship. Lordship kindly give direction to that authority to confirm. Thereafter, after coming to the report the authority will consider
We'll have it next week. I can barely hear you. Madam, my issue is that as far as the gradation list of 5/7/2021 is concerned, that has already attained finality. Where have you mentioned that it was challenged before the single bench and then eventually before the division bench and eventually before the Supreme Court? Where all have you mentioned in your pleading?
If you petition, facts are not in the petition.
time to the petitioner made objection that there is
Madam, where have you pleaded? Madam, where
have
have you, madam, where have you pleaded all this? Where are the judgments? Where are the judgments?
Lordship, make it not the lordship. I have to place the judgment lordship. I have the judgment lordship. Make it not to be lordship.
The request of the learned counsel petitioner, let this matter be listed. Due to technical glitch, the petition appears through VC. Due to technical glitch, she requests for an adjournment. Let this matter be listed. 7th. We'll keep it on the 7th. When do you want? 14th?
Lordship, more one thing, lordship, the validation certificate, lordship, can be directed the respondent to certify whether the certificate was valid or not.
When do you want? 7th or 14th? 14th. 14th.
My lord.
Rest of the matter we'll have after lunch.
This week we have not withdrawn this writ, so if your lordship permits us.
You want to withdraw it?
Withdraw it in view of a more comprehensive writ having been filed.
Gopal.
In view of this writ petition, which is now pending, owing to subsequent events. Item number 26. This is a subsequent writ which took place because of subsequent events.
I'm not recording anything. I'll just
in view of this writ, Lord, I'm seeking withdrawal. Otherwise, Lord, abandonment might come in.
Learned counsel for the petitioner states that he has filed WPO number 383 of 2025.
Lord, WPA number 12500 of 2025, and accordingly he seeks withdrawal of this.
WPA 1200 12500. Wow.
Let's say
12500 of 2025. In view of the same, he wishes to withdraw the present writ petition. The same is dismissed as withdrawn.
Obliged, Lordship.
No, WPA, not WPO.
The other one,
WPA 12500 of 2025.
Obliged, Lordship.
Yes, Mr. Manager.
Item number 10 was
Yes. 10 was fixed, but Mr. Mukherjee is there, right? Mr. Ghosh, Mr. Ghosh.
Not very short conspectus of the matter.
Yes.
I am the owner of the 7th floor of Nico House. Nico House is a commercial building in central Calcutta. I have, after purchasing the premises in question in liquidation, my lord, I have become the owner. I am owner by registered conveyance. There is no question of being put in possession by an agreement for sale or otherwise.
But in auction.
In auction. Nico Industries went under liquidation. Mr. Kothari was appointed as liquidator. From him, I have purchased portion of the 7th floor. I am the owner in occupation. There was a complaint made in the Kolkata Municipal Corporation that Nico House is not totally covered by a sanction plan. According to the complaint, the top 3 floors of Nico House are not covered by any sanction. These floors have been existing from last 30, 40 years or 50 years, but the allegation was that they are not covered by any sanction. Number of proceedings, my lord, were initiated. Now, my lord, insofar as the matter is concerned, my lord, proceedings under section 400 subsection.
Just a minute. This matter will go on. So rest of the board is discharged. The rest of the board is discharged. All right. Yes.
Okay.
Yes.
Now, my lord, kindly cease. Yes. Oh, but the confusion is here. The general terminology is the other matters stand released. Therefore, rest of the board is discharged. Is creating a few question marks, which they have now understood. Why now they have understood? Yes. Yes. For the day. See a lot of question marks. As
lot of question marks for me also at times. You know. I don't want lawyers to unnecessarily wait here.
Today, my lord. Okay. So, my lord, 400 proceeding, my lord, was initiated under.
Let them enjoy the weather.
Yes. I mean, and the cruel thing about the weather is this 10 or 7 or 8 days in Calcutta has been the best possible weather for enjoyment of various kinds and at various places. But unfortunately,
all my other colleagues are enjoying the weather too.
They're all. Then, my lord, I think, my lord, we should also enjoy the weather. After, my lord, after doing justice to what I am appearing for, I would make a prayer, my lord, very humbly and slightly later, because I am told everywhere else the board has been exhausted
everywhere.
Should we trouble your lordship? I'm thinking aloud. I can't ask a question of a judge. There's just 2 things I would want to point out and we end today very quickly so that, my lord, Mr. Ghosh can come and react. The question arose was that I am an owner of the 7th floor. A proceeding under section 400 subsection 1 has been initiated. In that proceeding, the special officer building was hearing the matter. I have not been put on notice. Special officer building passes an order in which he calls for all the records to be produced. Then he calls for a structural certificate, stability certificate of the entire building. So he's in the process of collecting records for the purpose of applying his mind. Suddenly, on one day when he had directed production of the entire structural stability certificate, and that was not before him, and he adjourned the other matters, qua the 7th floor, where I am the owner in possession, he directed demolition. While the other part of the proceeding is continuing.
Yes.
And pursuant to that, my lord, there was an order for engagement under section 544 read with 546. Corporation served me a notice of engagement saying that we have engaged demolition contractors. We are coming to demolish your building. I was taken aback. I went and contacted. I heard that an order had been made against me. I had to rush before this honorable court because I did not have, my lord, anything, my lord, by which I could go and throw a challenge at the statutory tribunal level. This honorable court was pleased to protect me. Subsequently, my lord, it occurred that there has been such an order made almost at an interlocutory stage qua the other constructions, but regarding me without any separate thing, anything to separate me from the grain from the chaff, against me suddenly an order of demolition is made. So that is challenged. My lords have protected me for a limited period. Parties have been heard. The question then arose that this order is appealable before the municipal building tribunal. So if I have got limited protection, my humble submission to your lordship was that your lordship protects me for a further while, a limited period, so that I can go and file an appeal. And if I'm entitled to the benefit of 14 in this, I'll get a benefit. If not, it's for the appellate forum to decide. For
Mr. Ghosh had an
Mr. Ghosh said, Mr. Ghosh then, my lord, and very, very tritely pointed out that I, being the part owner of a floor of a building, may not have an opportunity of hearing at all before 400 subsection 1 authority, first forum. And in terms of a judgment which has been delivered by this honorable court, may not have a right to file an appeal because I don't have a right of hearing before the first forum. So Mr. Ghosh's objection was that today, person aggrieved within the meaning of section 400 subsection 3 does not contemplate me, and therefore no statutory appeal is available to me. He would perhaps submit a step forward saying no remedy is available to me. He's not gone that far yet. At that stage, my lord, my lord was pleased, my lord, to tell me to come ready with the relevant part of the law. There is a division bench judgment of our honorable court, which says quite akin to what Mr. Ghosh has submitted, but this is in case of a tenant.
Yes.
This is, my lord, Vijay Vishwakarma versus Rajkumari Devi, MAT 2279 of 2023. Here, my lord, the question arose. Now, my lord, why I will cut this short is this. Here, the questions were framed as to whether a tenant has a right of hearing under 400 subsection 1 and has a corresponding right to file appeal under subsection 3. It was answered in the negative, saying that a tenant does not have such right, relying on a single bench judgment of our honorable court passed in another matter, that is Sanjay Mehta, which I'll be placing presently, and a division bench judgment in the earlier act. They were relied on. Lord, today I will not dilate too much on this for the simple reason that from this judgment, an appeal was carried before the Honorable Supreme Court. And in the appeal, the tenant in question was given an opportunity to go back to the first forum and apply for regularization after leave having been granted. So this is what I would humbly submit, Lord, would fall for your Lordship's consideration. 2024 SCC Online SC 2918. This emanates from, my lord, this judgment which I have placed before your Lordship. Please come to here. Now, Whether this is 142 or 141 will be something which will be argued, I'm sure, by Mr. Ghosh. According to me, this becomes Article 141 because the Supreme Court hasn't said anything regarding 142 applying here. Leave has been granted. Now, grant of leave means there's merger. If there's merger, then the division bench judgment is subsumed by this. This says that in the event the tenant makes an application, it will be open to the tenant to make an application for regularization and for the corporation to consider the same, and has taken undertakings from the tenant that since you're before the Supreme Court, now it is your last forum. If your application fails on cogent grounds, then you undertake to vacate. That was not the undertaking taken. Now, my humble submission would be, in view of this, because of the leave being granted, Bijoy Vishwakarma versus Rajkumari Devi division bench no longer remains. It is subsumed by this judgment. There can be a counter argument that it has not been gone into and therefore this still survives.
No, Mr.
Yes. So for that, Lord, I'll be required to satisfy your lordship on that. This is a tricky question.
Because the Supreme Court has only granted a very limited relief. And it has got nothing to do with the interpretation of any agreed person at all. This is just because somebody is pleading and at times we say, okay, fine, you file your regulation application, what will happen? We'll see that. Something of this sort.
I'm at one with your lordship, Lord. Ordinarily, such things are
They have not gone into the merit of the matter. They have not set aside the judgment of the
Findings on
petition
merit.
bench or the findings on merit. This is just that, probably they might have had a sympathetic approach or view towards the person concerned. They said, okay, fine, you go ahead, you file your regulation application, subject to the KMC deciding it.
Now, the question is whether there would be merger because leave has been granted. All these observations, my lord, are ordinarily made if your lordships consider.
Merger would have been if there was a substantive finding.
Discussing either. Yes, I am at one with your lordship here. But once leave is granted, now Kunhaya Ahmed has been reaffirmed by the Supreme Court saying, once leave is granted, then there's automatic merger. Even if there's a single line dismissal, single line approval, there's automatic merger. So that is something which I would want to argue. I am grateful that your lordship, my lord, has exactly shares my thought. Exactly shares my thought. That is my prima facie thought as well. Though this appears to be to provide me a thin line of argument on that, I have other lines of argument saying that this judgment went sub silentio on the question of natural justice, which is the main question, for which I'll address your lordship. But today, my lord, taking into account, my lord, the circumstances, surrounding circumstances and everything, I've just given Mr. Ghosh this also to ponder. If it is possible, my lord, that we could come back to your lordship any day, where I'll make arguments on this, where my lord is prima facie not impressed, and I'm grateful because that was also my view. Difficulty is leave granted. Now it appears what the Supreme Court has said after affirming Kunhaya Ahmed is this. Once the Supreme Court says leave granted and subsequently says anything different from what has been said in the court below, merge. So this, despite not having been considered, goes. I'll give you, lordship, a very good example of how of a similar matter in which this happened. In Khaitan Consultants matter, a division bench of our honorable court for the first time held that there cannot be any concurrent lease. Once there's a lease in India, you can't have another lease of the same property, because lease in India is a transfer of the right to enjoyment. Once you've given it, you don't have anything left. You can have a sublease, underlease, and X number of underleases, but you can't have a concurrent lease. That was the view taken. Now, Khaitan Consultants was given by a division bench. Khaitan Consult, in that matter, some of the parties or one of the parties went up before the Supreme Court. The question arose as to whether an application for amendment which was pending at that point of time should have been considered first or the judgment delivered. The Supreme Court said that because there's an application for amendment pending, the division bench ought to have decided the application for amendment first without going into that question, granted leave, and made that order. As a result of which, by implication, that order goes. Because leave has been granted. There's the trick.
No, the trick is there. But then the point is that
if he doesn't apply mine, so what? So Supreme
there's
Court
an
has
amendment application. So rightly so, the application has to be considered first, because the person is trying to amend the entire petition.
In that case, it was just a schedule of a part. Had nothing to do with the point of law involved.
Amendment has to be decided first. Basic principle.
Yes.
So rightly observed by the Supreme Court.
And as a result, the division bench judgment which held that concurrent leases are not maintainable goes. It went.
Goes because there's a reason for it. That
Yeah, I can understand. So I am at one with your lordship and your lordship remarks, my lord, that completely one with your lordship, my lord. As a student of law, I cannot really, because seeing this, it doesn't appear that the Supreme Court had any occasion to go into the merits of the division bench judgment or the conflicting issues therein. Therefore, my lord, the Supreme Court gave him a benefit which the court could even otherwise have given under Article 142. So 141 or 142 aside, the division bench survives, but for the leave granted. There, my lord, I'll show you, lordship, my lord, I've prepared some judgments. Leave granted means automatic finish. That is what now the Supreme Court perhaps has said. I'll be happy if your lordship holds against me on this point at least, because then that will help me. There are various cases in which, my lord, leave is granted and a portion of leave granted, nothing said about the judgment under appeal after grant of leave. So at the civil appellate stage, it is dismissed. Or let us say it's modified. If it is modified, the earlier part remains and subject to the modification. What if something absolutely new has been said? Like here the court says, Mr. Writ Petitioner Appellant, please go before the corporation, make an application for regularization. It will be open for you. So gives him the liberty and says that the corporation has to consider it. If it is unsuccessful, so there is no jurisdictional bar. If it is unsuccessful on merits, then you vacate. Now, this is akin to 142. It has the trappings of 142, not 141 of the Constitution, but leave has been granted. Now, this part I'll be arguing, and another part I'll be arguing, Lord, in Vijay Vishwakarma was that I had said, Lord, also submitted on the earlier occasion when I had prefaced this. My humble submission was the question to ask in case of person aggrieved, in qua an opportunity of hearing, is the consequence and not the right. Correct. Even if I am a person having no right over a property, but I suffer an adverse civil consequence, let us say by some law.
Ridge versus Baldwin.
Absolutely that. Squarely applies. And now it has been followed. In fact, in 23, I have found that Ridge versus Baldwin line of cases has been further developed in England by the English Supreme Court now. They have brought forward. So that is the question to be asked. Here the question asked, unfortunately, because of incomplete or assistance on my part to the bench, the question asked was whether the structure in question has any existence as a property because it is alleged to be unauthorized. That in my responsible submission would be a conclusion which would come to at the fag end of the proceeding.
Yeah,
but
you were there. Why didn't you argue this?
My lord, I tried to argue my best, my lord, but we had a
now with
limitation.
this division bench staring at my face.
Now, if it is here again, sub silentio, Supreme Court has recently said, if the point passes sub silentio, then your lordship may be inclined not to consider that part as a binding precedent. And there's a difference. Here it was a tenant claiming under somebody.
Yes.
So derivatively also, one can say that his right has been represented by his owner. Here I am an owner of a separate portion. I am not, I don't claim under anybody so as to come within the res judicata concept or the representative interest concept. Now, these 3 or 4 very interesting questions of law have emerged. So while giving Mr. Ghosh this copy so that he can go through it, may I, my lord, request that your lordship adjourns it to some other date when your lordship can hear it out and finish it off. I'll come ready. In fact, I'm ready with the judgments. I wouldn't want to open it further because informally speaking, my lord, the weather perhaps prevents me.
I've already discharged my board, Mr. Trivedi.
That was the main problem. I was waiting since morning for one of my matter, which was item number 55, being very hopeful that today it will see.
You will get chance today.
Nobody will be there. And therefore, I was intending to mention the matter, but I thought that the entire day is there. Because my lord takes original side only on Thursday. And my unfortunate last Thursday also a resolution was there. And today also, therefore, my lord, I was intending to mention that matter whenever my lord can be given some precedence on the 7th.
We'll see.
My lord, I apologize.
We will see that. So, Mr. Ghosh. Yes.
As you lordship, please, Mr. Banerjee.
We'll have it next week.
Yes.
Whenever
But
you
next week I'll be difficulty because forest
Next-
at 2 p.m. alert in another bench matter has been
Next
fixed.
to next week,
next week,
14th,
14th of August. Sharp of the
at the request of the party, let this matter be listed on the 14th at,
At 2, if you're
wait, no,
No, no,
14th, 2 p.m. is,
Oh, it's blocked. Oh, I see. 15, 16 coming up, 15, 16, 17 coming up. 14 to 2
Can
p.m.
we-
for me might also be difficult.
can we have it on 28th then?
Yes, I think it's better. After that.
28th? 20.
2 p.m.
28th, then 2 p.m.
Because 14, my flight will be also sometime around 4 or 4:30. But there's a interim order in the matter which was still next Thursday. Could it?
Interim order granted earlier is extended further for a period of 6 weeks.
Oh, like
6 weeks or until further order, whichever is.
Oh, my lord, rises.
This is item,
Item number 55 of my lord's list. My premises is under lock and key, under a warrant of distress. I am a tenant, my lord. There is an arguable matter, my lord. If some precedence, I filed it, I had mentioned some precedent on next because my lord takes it up only on Thursdays, my lord. Yes.